Good afternoon. Thank you all for attending today's roundtable on the Trademark Modernization Act, or TMA, Notice of Proposed Rulemaking. The slides from today's presentation are posted on the TMA page on our website. This roundtable is being recorded and will be made available for viewing on our website within 2 to 3 weeks. If you encounter any technical difficulties during the roundtable, please email virtualevents@uspto.gov for assistance. If you have questions for the panel, please send an email to tm_webinar@uspto.gov. The panel will answer as many questions as possible during today's session. Now I will turn it over to the Commissioner for Trademarks, David Gooder, to provide opening remarks. Commissioner Gooder?
Thanks, Tasha, very much. Good afternoon, everyone. In a few minutes, you'll be hearing from Amy Cotton, the Deputy Commissioner for Trademark Examination Policy at the USPTO. Amy's going to take you through the proposed rules for the TMA in order to implement it. Before she does, though, however, I wanted to share with you a few thoughts of mine about the TMA. If you haven't already heard, this year marks the 75th anniversary of the enactment of the Lanham Act. Our trademark law has stood the test of time. Important amendments over the years have been few, but when they have been, they've been significant. This is the case with the TMA. When the Lanham Act was passed, the world was a very different place, however, and the challenges we face today with regard to the integrity of the register and its registrations simply weren't part of the landscape. So the TMA has come along at an opportune time, and in implementing, we wanted to do two things a bit differently than we've done in the past. First, we sought comments and input from stakeholders and our customers early in the process to get their initial thoughts about implementation. We included many of those comments in the draft. Second of all, you'll notice when you've read it that we included in the draft a number of options for some of the rules and procedures. Our thought was that by doing this, you'll be able to consider some of the things we were considering and be able to provide productive comments in areas where more than one good option is possible. In this way, when the final rule is published, we're confident that the rules will have been well thought through, will be effective, and generally supported by the trademark community. As I prepared my remarks for today, my thoughts turned to the protection of our trademark register, which is one of the bedrocks of the trademark ecosystem. Quite simply, the integrity of the register ensures that brand owners are able to protect their IP and succeed in the US and global markets. It's for this reason that protecting the integrity of the US trademark register is and will remain for some time one of our absolute top priorities. In that vein, we welcome the TMA, as we believe it will contribute in a significant way to that goal. So enough from me. Let me now turn it over to Amy Cotton, our Deputy Commissioner for Trademark Examination Policy. Amy?
Thanks, Dave. Good afternoon, ladies and gentlemen. I'm delighted to be here with you alongside my distinguished colleagues here at the USPTO to share our plans for the implementation of the provisions of the Trademark Modernization Act of 2020. Joining me today are, as you heard, Commissioner Dave Gooder. We've got Deputy Chief Judge Mark Thurman. We've got Deputy Commissioner for Trademark Operations, Dan Vavanese, and the Senior Trademark Legal Policy Advisor, Robert Lavache, who's very much responsible for the rule package that we're talking about today. The Notice of Proposed Rulemaking, I'm going to call it the NPRM for short. The NPRM for the TMA issued on May 18th, a bit ahead of schedule, which was quite nice. The comment period is 60 days. That means that your written formal comments are due to the regulations.gov portal by July 19th. Your comments must be submitted to the regulations.gov portal in order to be included in the records of our formal rulemaking process. The TMA NPRM contains proposals to amend the existing letter of protest rule to indicate that the letter of protest determinations are final and non-reviewable. It establishes flexible office action response periods. It establishes ex parte expungement and reexamination proceedings for cancellation of a registration when the required use in commerce of the registered mark has not been made. It provides for a new non-use ground for cancellation before the Trademark Trial and Appeal Board, And the rule package also sets fees for the petitions requesting institution of the ex parte expungement and reexamination proceedings, and for requests to extend office action response deadlines. Also in the rule package are amendments for the rules concerning suspension of USPTO proceedings and the rules governing attorney recognition in trademark matters. Finally, we've got a new rule proposed to address procedures regarding court orders canceling or affecting registrations. All the rules in the NPRM are subject to change based on your formal comments. Remember, your formal comments submitted to regulations.gov. These rules will not take effect until the date indicated in the final rule. For expungement and reexamination, however, implementation is required by the statute by December 27th, 2021. For the flexible response periods, the TMA does not dictate a date of implementation, and so the USPTO has proposed in the rule package that we might delay implementation 6 months. So that would be June 27th, 2022. That's for the sake of your docketing systems as well as ours. Any input today that we receive via email or through folks providing comments or questions online is considered informal and will not form part of the formal rulemaking record unless submitted in writing to register.gov, regulations.gov, pardon me. We're going to start with the letter of protest. The USPTO issued rules formalizing the letter of protest procedures consistent with the TMA at the end of last year. So all that's left for us to do right now is to tweak Rule 37 CFR 2.149 to mirror the statutory language, that any determination by the USPTO director whether to include letter of protest evidence in the record of an application shall be final and non-reviewable, and that any such determination shall not prejudice any party's right to raise any issue and rely on any evidence in any other proceeding. I would note, because I've gotten questions on this point, that codifying the existing letter of protest procedure has not resulted in any changes to the practices that have been in place for many years, except for two things, minor things. Now, there's a fee now for $50 when you file a letter of protest, and under the statute, the USPTO now has 2 months in which to make a determination on whether to send the evidence submitted by the protester to the examining attorney for consideration. So these are minor changes, but everything else is the letter of protest procedure that you've known for many, many years. Now, the second big bucket in the TMA is the flexible response periods. So in the NPRM, you might notice that in the rule text, we have one option for how we could see flexible response period implementation working, but we actually offer two other options in the text. It's in the explanatory section, so you might want to view those three options and see what you think. All options would apply to the response periods in examination as well as in post-registration. However, the shortened response periods would not apply to a Section 66A Madrid application or registration. The various treaty provisions and procedures in the Madrid system for the international registration of marks at the World Intellectual Property Organization would make it very difficult for international applicants and registrants to meet those shortened response period deadlines in the United States. So we have proposed to carve them out in the implementation. So the NPRM has three options. The first option, pretty straightforward. A standard 3-month response period for all office action, extended one time to the full 6 months. We're proposing an extension fee of $125 per request. This is not a per class fee, this is a per request fee. Our thinking was that we might wish to propose a shortened period for only those responses to office action that contained simple requirements, but it became very difficult to distinguish which office actions could be considered simple and which would be more complex without leaving it up to an individual examining attorney on a case-by-case basis. A bright line rule seemed easier for everyone's docketing system and consistent with the intent of the TMA. So this proposal is reflected in the NPRM rule text. Option 2, it contained in the explanatory section, it proposes 2 separate response periods that could form the basis for implementing what we call a 2-phase examination system. The first phase would be for formalities examination, and it would feature a 2-month response period initially. Under the TMA, this would then be extendable in 2-month increments up to the full 6 months upon request and payment of the fee. The second phase would be for substantive examination, and it would have a 3-month response period, also extendable up to the full 6 months. Now, if you do the math, you would realize that this option could result in an increase in total pendency for a particular application if all extensions are pursued. But we are looking at it because it could give us flexibility to handle the formalities issues first, issue an office action, and then come back for the substantive examination separately. We'd love your comments on that. Option 3 is the patent model. We couldn't get away with a rule package for trademarks that didn't have some piece of patents in there, and here we have option 3. The initial response period in every case would be 2 months, but it could be extended in increments up to the full 6 months. The applicant would file the extension request and fee within the response period. The extension fees get progressively higher as the applicant requests more time to respond. So, like for instance, the first extension fee could be $50 for a third month, and $75 for a fourth month, and $125 for a fifth month, and $150 for the full 6 months. The application is abandoned if the deadline is missed without the extension request. To revive, the petition to revive must include the applicable extension fee, depending on when the petition is filed after the initial missed deadline. We would appreciate your comments on which of these options would be most useful to you. Now, the third big bucket in the TMA and in this rule package are the non-use cancellation, the new non-use cancellation mechanisms. So these new proceedings for canceling registrations for non-use, the NPRM has the procedures to implement these proceedings. So the first one is expungement. The target of these proceedings is a mark in a Section 1 use-based registration, a Section 44 Paris registration, or a Section 66 Madrid registration, where the mark has never been used on all or some of the goods identified in the registration. The petition to request institution of the expungement proceedings may be filed in the window of time between year 3 and year 10 after registration. The TMA also provides that expungement is a new ground for cancellation at the Trademark Trial and Appeal Board. However, keep in mind the timing is a bit different for a TTAB claim. The claim is available at any time after the first 3 years post-registration. It does not cut off at year 10 like the proceedings before the director. Please note that the claim of expungement does not affect any other already available non-use claim at the TTAB, that is abandonment or non-use, nor does it impact the timing for those claims. Now, I want to be very clear that expungement and abandonment are two different claims. Abandonment requires, as you know, the intent issue comes into play, and with expungement there is no evaluation of intent. So I want to be clear that those are two different claims. A further point on the timing of these petitions, just keep in mind the TMA provides for 3 years from enactment to 2 years from implementation that a petition for expungement may be filed against a registration that's over 10 years old. So for the next 2 years after implementation, a petition for expungement can be filed at any registration, regardless of that window between year 3 and 10, any registration that's 3 years old. The intent is, of course, to provide that the clearance of older deadwood off of the register for this 2-year period, that it should be accelerated during that period, clear off the deadwood, and clean up the register early. Now, the second proceeding is called reexamination, and the target of these proceedings is a mark in a Section 1 registration that was not in use as of the relevant date. The relevant date for purposes of a proceeding in a Section 1A application is the filing date, presuming that it was not amended at any time to a Section 1B filing basis. Then the relevant date for purposes of a Section 1B application is the later of the filing date of the amendment to allege use or the expiration of time to file a statement of use. A petition to request institution of reexamination proceedings may be filed in the first 5 years after registration. For both expungement and reexamination, those time periods are critical. Once that window for requesting proceedings is closed, these tools before the director are no longer available. But, of course, any interested party can always bring a claim before the TTAB or a federal district court for non-use, abandonment, expungement as appropriate. Now, the NPRM lays out the matching procedure that will be followed in both expungement and reexamination proceedings. In both, we're proposing a $600 per class petition fee. The fee is designed to strike the balance between cost recovery and providing a less expensive alternative to a contested TTAB proceeding. Any person may file a petition requesting that either an expungement or reexamination proceeding be instituted. Only one registration per petition will be allowed, and the basis for that petition must be either expungement or reexamination, but not both in the same petition. Combining them into one petition creates some IT difficulties and could be problematic for examination because the evidence for the different bases will be different. However, even if the petitions are required to be filed separately, the director can consolidate review of multiple petitions against the same registration. Now, the TMA says any person can file, so the statute itself makes clear that there should be no standing requirement for the petitioner. The petitioner is not anonymous because the petition must be filed through TEAS, and that means through a USPTO.gov account. Also, the petitioner must provide a domicile address so that we can determine if the petitioner is foreign domiciled, and thus would need to include the designation of a U.S. attorney in the petition. If the attorney is designated, the petition must include the attorney name, postal address, email address, and bar information. If a petition is filed but is incomplete, the USPTO may issue a 30-day letter to address the missing information. Now, I kind of wanted to circle back to the anonymity question that I do get a lot, because I wanted to note the USPTO is not currently proposing that the petitioner be required to identify the real party in interest. We're doing this for two reasons. First, if the petitioner establishes a prima facie case of non-use, then theoretically it makes no difference for purposes of adhering to the intent of the TMA who that petitioner is or whom he or she is representing. The ultimate goal of the proceeding is to clear deadwood from the register regardless of who requested the proceedings. Second, once the petitioner files the petitioner is out of the process. To hold the petitioner accountable in the context of the proceeding for failing to provide accurate information as to the real party in interest would require the petitioner to be a party to the proceeding throughout, but that was not the intent of the TMA. Instead, we have an option. We believe that the petitioner who uses the proceedings to harass registrants could be sanctioned outside of the context of the proceedings, that is, through the sanction authority of the Commissioner for Trademarks. The Commissioner for Trademarks may sanction individuals making submissions to the USPTO for improper purpose. If the USPTO were to discover through our ongoing investigations for fraudulent and bad faith submissions that a petitioner was actually abusing the proceedings, the USPTO could preclude submissions in any proceeding before the USPTO by that petitioner and the party the petitioner may be representing. We could also terminate any USPTO.gov account created by the bad actor. So for an example, the ethical duty of candor that applies to any party practicing before the USPTO would be violated and subject to sanctions if the petitioner did not disclose all material facts known that would enable the office to make an informed decision whether or not the facts are adverse. This would include situations where the petitioner knew that a mark was in use when the petition alleges that it was not. So once a complete petition is filed, a courtesy email notice of the filing of the petition will go to the registrant and the registrant's attorney. The petition and evidence will also be uploaded into the trademark status and document retrieval system and made public. No response from the registrant to the filing of the petition will be accepted unless and until proceedings are instituted. Now, the petition must include that verified statement that identifies the elements of the petitioner's investigation of non-use. Where did you search? How did you search? When did you search? What did you find as to each source of information relied upon? Now, of course, the reasonableness of the search and the number and nature of the sources the petitioner must search will be determined case by case, because the evidence of non-use that's sought will necessarily differ depending on the nature of the goods and services at issue in the proceedings and their relevant channels of trade and advertising. Now, those sources must be reasonably accessible and ones that can be publicly disclosed. Appropriate sources of information and evidence for a reasonable investigation may include, but are not limited to, state and federal trademark records, internet websites, and other media likely to or believed to be owned or controlled by the registrant, internet websites, other online media, and publications where the relevant goods and or services likely would be advertised or offered for sale, print sources and web pages likely to contain reviews or discussion of the relevant goods and or services, records of filings made with or of actions taken by any state or federal business registration or regulatory agency. Additional sources, the registrant's marketplace activities, including, for example, any attempts to contact the registrant or purchase the relevant goods and or services, records of litigation or administrative proceedings reasonably likely to contain evidence bearing on the registrant's use or non-use of the registered mark, and, of course, any other reasonably accessible source with information establishing that the mark was never in use in commerce or was not in use in commerce as of the relevant date on or in connection with the relevant goods and or services. Now, the prima facie case. The director is the gatekeeper to the process, and the director decides whether a prima facie case is made based on evidence and information in the petition and the USPTO's electronic record of the involved registration. Now, the director also has the authority to institute a proceeding without a petition if the director has evidence establishing a prima facie case. For example, the director could institute a proceeding on different goods and services in a registration that's already the subject of a petition-initiated proceeding. Now, of course, the director can consolidate review of both proceedings on that same registration. So consolidated proceedings are related parallel proceedings that may include both expungement and reexamination grounds, but it's the same registration at issue. A prima facie case requires only that a reasonable predicate concerning non-use be established. If a prima facie case is established, the director must institute proceedings. And if proceedings are instituted just as an examination, the burden of proving non-use by a preponderance of the evidence lies with the director. If a prima facie case is not established in the petition itself, the director will not institute petition-based proceedings. The director will not add evidence to a deficient position to establish a prima facie case and institute proceedings. But if the director has his own evidence that establishes a prima facie case, the director could institute proceedings on his own initiative without a petition. Once proceedings are instituted, an office action will issue that directs the registrant to respond within 2 months with proof of use of the mark on the challenged goods or services. The director's decision to institute proceedings based on a prima facie case is final and non-reviewable. Now, the registrant has 2 months to respond, and the registrant is subject to the USPTO's rules on electronic correspondence, domicile address, and representation by U.S. counsel if foreign domiciled. The registrant really has 3 options for his or her response. Number 1, provide evidence of use. Number 2, provide evidence of excusable non-use. And 3, deletion. Let's start with the first, evidence of use. The registrant must provide such evidence of use information, exhibits, affidavits, or declarations that may be necessary to rebut the prima facie case by establishing that the required use in commerce has been made on or in connection with the goods and services at issue as required by the Lanham Act. Any documentary evidence of use need not be specimens of use in the Section 1A of the Act's sense, but must be consistent with the definition of use in commerce in Section 45 of the Lanham Act. Now, specimens are typically what will be provided, we think, but there may be situations where the specimens are no longer available. In these cases, the registrant can provide additional evidence and explanation supported by declaration. Resubmitting the same specimens already contained in the USPTO's records without additional evidence will likely be insufficient to rebut the prima facie case. You have to keep in mind that the office has already reviewed USPTO's records to determine whether or not to institute proceedings. So the specimens that are already in the record are not going to work. We've seen them. Testimonial evidence must be submitted, but should be supported by corroborating documentary evidence. For expungement, the proof of use must show that the use occurred before the filing date of the petition. For reexamination, the proof of use must show that the use occurred on or before the relevant date. Now, the second bucket of responses is excusable non-use. However, this is narrow. This only applies to Section 44 or 66 registrants in the context of an expungement proceeding. Excusable non-use is a treaty entitlement for Paris and Madrid registrants, and it does not apply to Section 1 registrants. It only applies in expungement because Section 44 and 66 registrants did not have to establish use in examination as a condition for registration that would now be questioned in a reexamination proceeding, so it's just not applicable. Okay, so that third bucket of deletion, right? A registrant may delete some or all of the challenged goods and services in his or her response with immediate effect. A registrant may not amend an identification in the context of these proceedings, though. And we received a question about this at the last roundtable, whether any regulatory allowances would be made for registrants in an expungement or reexamination proceeding who are affected by a mistake made by counsel in identifying the original goods and services. So a fact pattern that explains this, if the proof of use does not match the identification of the goods and services being challenged, maybe this was because the applicant initially made a mistake in identifying the goods and services in his application and never fixed that mistake. Now, the registrant in the context of this proceeding may not amend the identification to match the proof of use. However, there is a way around this. The registrant could file a Section 7 amendment to narrow the ID within the scope of the original and notify that amendment to the expungement or reexamination examiner for consideration if the registrant did not do so prior to the proceedings. Keep in mind that we cannot guarantee the Section 7 amendment would be accepted, and also keep in mind we would not actually suspend the examination, the expungement or reexamination proceedings, but we would try to expedite consideration of the Section 7 amendment. Now, if the registrant's response proposes deletion, but the timing of this deletion occurs when the same registration is also in the middle of a post-registration examination of the Section 8 or 71 declaration. If that deletion happens to happen at the same time, the post-registration examination deletion fee kicks in. The deletion fee of $250 per class will be due. If you recall, in January 2021, we implemented a deletion fee if the goods or services had to be deleted in a post-registration examination or a post-registration audit. And we don't want the expungement and reexaminations proceeding deletion to be a way to get around that $250 deletion fee. So if they happen at the same time, that deletion fee is still due. Now, I want to note specifically here that we are not proposing to charge a deletion fee in the context of the expungement and reexamination proceedings, because we want to incentivize deletion in this context, and in the sense that post-registration maintenance examination is a separate, different proceeding than one we're looking at here. So in this context, generally we're not charging that fee deliberately so, but let us know if you think we should in your formal comments. Now, the registrant can delete goods in the response, but they could also delete goods and services through a Section 7 amendment. We need to know about that. The Section 7 amendment must be notified by the registrant in your response to the expungement or reexamination. And the same thing is true with a voluntary surrender of the registration. You can do that as a separate proceeding, but it has to be notified to us through the response. Now, if any one of these responses happens and we consider it to be acceptable, the proceedings will terminate immediately and no cancellation order will issue. Now, if the registrant's response is either a non-response or an unacceptable response, that's what we're going to look at here. No response results in immediate cancellation for the goods and services on which the proceeding was instituted. Now, a petition for reinstatement is available if the failure to respond was due to extraordinary circumstances. The typical time periods for filing those sorts of petitions apply. Now, of course, the response to the outstanding office action will also be required along with that petition and the fee. We don't want this process to be used to prolong the registrant's overall response period. And remember, bears notice that the NPRM adjusts the due diligence monitoring rule such that the registrants must monitor the status of the registration at least every 2 months after in notice of institution of proceedings. So you've got to be alert once these proceedings are instituted. You have a due diligence requirement to check every 2 months. If the response is unacceptable or it's incomplete, a final action issues with a 2-month response period. We actually are asking for comments in the NPRM on whether we should issue a 30-day letter for a timely bona fide attempted response to the first office action, but which omits some small matter of compliance. I wanted to go back to the issue of deletions, though, that third bucket, and flag 2 issues that I'd love for you all to comment on in your formal comments. The NPRM specifically requests comments on whether a registrant who fails to respond to the office action should have his or her registration flagged for later audit. This means, from a best practices perspective, not responding to the office action and allowing a deletion to occur without affirmatively responding and deleting the challenged goods and services would no longer be an option. Our thought in asking for comments about an audit is that a registrant who simply does not respond may have bigger problems in his or her registration for which evidence of non-use was not available, but in fact, the mark was not in use for additional goods and services in the registration. So if we target it for later audit, we can find out if the rest of the registration that was not challenged in the proceeding holds up under further scrutiny. But we are aware that such a policy could raise another issue for foreign domiciliaries who may not wish to respond to an office action because they don't want to have to get U.S. counsel in order to affirmatively respond. They might prefer to let the challenged goods and services fall away, and they might not want to hire an attorney to make that deletion or to surrender the registration in order to avoid the later audit. But maybe, on the other hand, that's not something we would like to consider. So we kind of would like to have some comments to determine, is there a way for a foreign domicile registrants to be able to respond to the office action and simply delete without having U.S. counsel? Or does that create a disincentive for foreign registrations to use the existing no-cost mechanisms to keep their registration up to date all the time? So we'd love your input on that piece. Now, the response to the final action. The final action will include the examiner's decision in an expungement proceeding that the registration should be canceled for each goods or service for which the mark is determined to have never been used in commerce or for which excusable non-use was not established, or for non-compliance with any requirement under Rule 2.11, U.S. Counsel, Rule 2.23, failure to provide an email address for electronic correspondence, or Rule 2.189, failure to provide a domicile address. The final action for reexamination proceeding would include the examiner's decision to cancel the registration for each good or service for which the mark was not in use on or before the relevant date, or for noncompliance with the same rules I just mentioned. The registrant must respond to the final action with a request for reconsideration and a notice of appeal. Now, if there is no response to the final action, the USPTO will terminate proceedings and order cancellation of the goods and services that were challenged. Again, a petition for reinstatement is available, but only for an extraordinary situation. Keep in mind, if the request for reconsideration contains acceptable proof of use, we will terminate proceedings and no cancellation order will issue. But otherwise, the examiner's decision to cancel would then go to the Trademark Trial and Appeal Board, and the regular board timelines will apply. Goods and services for which use in commerce has already been established may not be subject to further expungement or reexamination proceedings. This is the Estoppel provision in the Act. But keep in mind, this Estoppel provision does not apply to subsequent board proceedings. So in other words, even if a registration is subject to an expungement or reexamination proceeding before the director, that registration may still be challenged at the TTAB on a claim of expungement, abandonment, or non-use as appropriate. So as for pending proceedings, we cannot institute expungement proceedings on the same goods or services if an expungement proceeding on those goods and services is already pending. We can't just keep loading up on the same registration. Likewise, we will not institute an expungement or reexamination proceeding if a reexamination proceeding is already pending on those goods and services. We will deny the later filed petition unless it covers goods and services not already the subject of an instituted proceeding. We have proposed to amend the rules so that expungement and reexamination proceedings are included among the types of proceedings for which suspension of action by the office or the TTAB is authorized. We are also proposing to amend the rules to reflect our current suspension practice. Generally, the TTAB will suspend proceedings when another proceeding that is relevant to the registrability of the involved mark is ongoing. However, the rule is currently written such that the suspension practice is limited to proceedings where the exact same party or parties are engaged in the other proceeding. So we are proposing to amend the rule to reflect our actual practice, and whereby we look at the relevance of the proceeding to the registrability of the registration rather than looking to the identity of the parties. Now here is a visual for those of you who think visually. This is an overview of the expungement and reexamination proceedings before the director. And these slides will be posted, they already are posted on our website, so you can take a closer look. But let's walk through this simplified version. So the process begins with the petition against the registration. It goes to the examiner. There are two possible outcomes: an institution decision. This would also be combined with the first office action. Or the other option is denial to institute. Now the next, the examiner, the registrant has 2 months to respond, and the examiner reviews the response. The registrant could have either submitted an acceptable response or an unacceptable response, or doesn't respond. An acceptable response moves forward, an unacceptable An acceptable response means termination of the proceedings immediately with no cancellation. An unacceptable response moves to the examiner and who issues a final action. No response results in immediate cancellation of the goods and services on which the proceeding was instituted, not the entire registration or the entire class, just the ones that were attacked and upon which proceedings were instituted. Now, the examiner can, like I said, terminate the proceeding, issue a final action, or cancel. Goes back to the registrant. The registrant has 2 months to respond. They can file, he or she can file a request for reconsideration, providing additional evidence. He can file also a notice of appeal at the same time, or he cannot respond at all. A non-response, again, will be tagged for later audit, but the goods and services that were attacked will be immediately canceled. The examiner reviews the request for reconsideration. If the examiner decides that the evidence submitted is acceptable, the proceedings will immediately terminate. If not, then it goes to the board, where the board will review the appeal. Now we're going to move on to some other features in the NPRM, not strictly driven by the TMA, but they are driven by our need to have clear correspondence rules and to implement provisions of our database login project. Now, overall, when you look at these rules in the NPRM, I want you to notice that we're moving away from using the term representation to the term recognition. We recognize here that the representatives for the purpose of determining who is authorized to act for the applicant or the registrant. We do not control the actual representation agreement between the attorney and the client, and we want to make sure that's clear in our rules. So we're changing the wording to reflect that reality. Now, as for the substantive change here, under our current rules, recognition ends when an application is abandoned, a registration expires or is canceled, or changes owners. Under the proposed rules, recognition would instead continue after all of these events. So that means that in order to end the recognition of the attorney by the USPTO, owners and attorneys would be required to proactively file an appropriate revocation or withdrawal document rather than the current situation where recognition automatically ends at certain events. Now, we want to make this rule change to match our practice. The background for this change lies in our correspondence rules. Now, the USPTO is supposed to correspond only with the applicant or registrant if the applicant or registrant is not represented by an attorney. So if recognition has ended after those events that I named, we should stop sending correspondence to the attorney's correspondence address, but we don't. Stakeholders told us not to follow our correspondence rule. Attorney stakeholders in particular told us they wanted to continue receiving correspondence so that they could know when the post-registration filings were due, for example. And so we want to amend our rule to reflect our practice. Now, the other part of this situation is this rule change will actually facilitate implementation of the role-based access control system for applications and registrations that we're right now developing. So if you recall, we implemented our database login project, phase 1, where in order to file any TEAS forms, you have to have a USPTO.gov account. We have 2 more phases coming. The second phase is an identity verification process for database login. And then after that, we've got role-based authorization. So in this situation, users are going to be assigned a limited number of roles so that they can control and delegate access to filings. And this would be, attorney, attorney support, owner, and public administrator roles. And only those people would be authorized to touch the file. And this will definitely cut down on any unauthorized changes of correspondence and the like. So under our current rule, if we were to retain that rule, in order to submit the TEAS form, say, for example, to file a maintenance document on behalf of a client, the role-based access controls would require the no longer recognized attorney to first request IT permission from the owner in order to file. And we're concerned about missed deadlines. That creates a lag in timing, and we know that that could be dangerous. So we want to fix the rules to match our practice and allow us to assign roles for access controls. We're also proposing a rule change to clarify attorney obligations when withdrawing from representation and differentiate the grounds upon which an attorney may request withdrawal versus those situations where an attorney must request withdrawal. And there really should be no surprises here. This will allow us to be consistent with the USPTO rules of professional conduct. Now, the last bucket of rule changes in the NPRM are about court orders. Now, this is pretty easy. We want to codify the USPTO's long-standing procedures concerning action on court orders canceling or affecting a registration under 15 U.S.C. 1119. The USPTO requires submission of a certified copy of the court order and normally does not act on such orders until the case is finally determined. We're just simply embedding this practice into a rule. So that was a summary of the rule package, and it was hopefully designed to facilitate your efforts to provide formal comments to regulations.gov. We hope that you will be able to help us refine this rule package into a final rule with which we can all be comfortable. And here's some information for you about how to submit formal comments and what the deadline is. Here are some helpful links. And remember, this is already posted on the USPTO TMA webpage. So here's some links for you. And then I thought it might be helpful for you all to have a set of reference slides that identify the rules implicated in the NPRM. And I'm not going to walk through them now, but they will be available on the slide deck. And you can see we have the letter of protest rule tweak there. We've got conforming amendments for shortened response periods. There's no new rules there, just conforming amendments. We have some new rules here for non-use cancellation and conforming amendment rules for non-use. And then we have the rules implicated with the recognition of representation withdrawal rules and the court orders. So I wanted to close my remarks with a suggestion. You might have noticed that as part of our initiatives to protect the integrity of the trademark register from false claims of use and fraudulent submissions more generally, we're implementing disincentives for maintaining inaccurate registrations, or perhaps more positively, I should say, we're incentivizing accurate registrations. So I mentioned before, one disincentive, which was implemented in January 2021, is that deletion fee in the post-registration context. The other is the TMA expungement reexamination proceeding. It's a disincentive to filing inaccurate and holding on to inaccurate registrations. So we want to incentivize maintaining accurate registrations, and one way we did that was to establish a zero fee for filing a Section 7 amendment, which deletes unused goods and services from the registration. So I really would highlight that, recommend that to registrants and their representatives to review their registrations for accuracy and make adjustments now through this free process. And doing so then is an easy way to avoid having one's registration targeted for a reexamination or expungement proceeding, or getting caught up in having to pay the $250 per class deletion fee in a post-registration maintenance examination or audit. So that was my public service announcement to help you think about cleaning up your registrations early and often. And now I'd like to hear what comments and questions that our speakers have today. And we actually got a bunch of questions pretty recently in the email box that we'll try to go through after we hear from our live speakers, and we'll try to get to as many as we can today. So if you have a question that you would like us to try to answer that hasn't already been answered, please email tm_webinar@uspto.gov, and they will those questions will be fed to us by Tasha. Oh, okay. So Tasha, turning it back to you.
Thanks, Amy. Our first speaker is Michelle Borer.
Michelle,
and audience,
you need
please
to
bear
connect
with
your
us.
audio.
Please bear with us as we try to elevate the speakers up to the panel.
Now? Can you
Yes.
hear me now?
Yes, we can hear you.
Okay, great. Thank you. All right. I want to briefly mention that I reviewed and read some of the comments that were on June the 1st. And I agree with some of the written comments from the counsel for Amazon, for the counsel, Miss London, at a private law firm, for the president at the American Intellectual Property Law Association, and the attorney for General Electric. And in so doing, I wanted to also add just a few things with a question. Number one is about the standing issue for the third parties. I'm concerned that there may be issues of retaliation from and by third parties, either against counsel or against the registrant. So how will, I guess specifically, Mr. Robert Lavache and his team, and please forgive me if I'm saying his last name incorrectly, how will that be dealt with? And then second of all, my concern is about the $250 deletion fee per class. Why that's so much money? It seems to be a penalty instead of an encouragement for doing the right thing. And then the 30-day letter is welcomed by me. The more notice you give the individuals in advance, the better and happier and more peace of mind you're going to be giving your PTO customers. In addition, I'm going through this very quickly because I don't want to, I want to be respectful of time. In addition, two last things. I know from personal experience that there's an issue that is never usually addressed. So I'm going to address it now for the first time, and that is the issue of incompetent counsel. Many times, applicants who then become registrants have had incompetent counsel, and they have to deal with the deck that they've been given. And they don't know how to correct things. They don't know what to do. So I understand about the withdrawal of counsel and the process and procedure that's needed. But I kindly, thoughtfully, and professionally ask and request that from henceforth on, the issue about incompetent counsel be at least considered and addressed. And then finally, on all the pages that I've noticed on the PTO's website, especially with the TMA, when you click the drop down, there's Facebook, there's Twitter, there's LinkedIn, there's Dig that I've never heard of, and Reddit. But the one symbol that's missing is the email symbol, because this is important information to share. In fact, all of the PTO information is important to share. And if the tech team can consider including next to the printer symbol, an email symbol that also joins, the symbol for Facebook, Twitter, LinkedIn, Dig, and Reddit, that would be wonderful. And that is my public comment. Thank you very much for your interest, your thoughtfulness, and your time.
Thank you, Michelle. I'm going to go through these issues as quickly as I can. On the question of standing, that question has been answered by the statute itself, and there's no standing requirement. Any person can file. In my remarks, I mentioned about whether we should, the USPTO should require the petitioner to identify the real party in interest. And I explained why we had not put anything in the rule to do that. Number one, if the evidence is there that the mark is not in use, it doesn't matter who put it forth. And number two, the petitioner is not a party to the proceeding. And bringing them into the proceeding, then we're in an inter partes proceeding, and the intent of the statute for a very quick and effective way to clear deadwood off the register sort of is lost. As I mentioned in my remarks, we do have the ability to look into situations where somebody is filing improper submissions to the office. The sanction authority of the Commissioner for Trademarks is something that we are now using to good effect when we are seeing bad faith or fraudulent submissions before the office, and we intend that we would use that authority in this context as well if a petitioner is using the proceedings for improper purpose. So we think we can get at it outside of the context of the proceeding itself without requiring the petitioner to be a part of the proceeding, which we can't do because the statute says that. So I just wanted to highlight that. The $250 deletion fee in the post-registration context, that is a rule that already issued for public comment and was implemented a while ago. Now, your point was it's a punishment or an incentive. It's a punishment. By law, by the statute, you're supposed to be filing a maintenance document that is accurate, and you are filing that and signing it on a declaration of perjury, 18 U.S.C. 1001. So to the extent that you're filing a document that's inaccurate, then we are imposing a penalty. And the background for that penalty is the fact that for, since 2012, we have run the post-registration proof of use audit. And 5,000 registrations a year are audited. And over the course of that time frame, 2012 to 2021, the 50% of the registrations queried deleted goods and services. 50% had inaccurate maintenance filings. 50%, and it was equal among foreign registrants and U.S. registrants. It was equal between 44 over 66 registrations and 1A registrations, and 80% of those were represented by U.S. counsel who were part of the process in filing an inaccurate maintenance declaration. So yes, it is a $250 per class penalty for filing an inaccurate declaration, and we're hoping that it will change behavior so that people will actually file an accurate declaration. So yes, that's the purpose of the rule, and we hope that it doesn't catch up too many people because we hope people are cleaning up their registration and filing accurate documents before the USPTO. As for the point about incompetent counsel, again, I addressed that in my remarks in the sense that their Section 7 amendment process allows registrants to correct whatever problems or deficiencies exist in their registration as long as it's within the scope of the original. And we would encourage everyone to clean up their registrations in order to do that. Make sure your proof of use matches the identifications of goods and services in your registration. If those problems haven't been fixed, then they need to be. When you file when a registrant files, submissions before the office and makes averments as to the truth of the statements made. So we would like to see that the quality of the submissions before the office improve, and we think all of these little changes that we're making are designed to do that. And as for the ICON, the tech team, we will definitely look into that. We appreciate the suggestion very much. So now I think we need to move to the next speaker, Tasha.
Thanks, Amy. Our next speaker is Alison Ricketts. Alison?
Hello, how are you? Good afternoon. First, I'm going to comment on your request for comment on the whether registrations that are the subject of a non-use proceeding should also be selected for the post-registration audit. My view on that is no, that audit is supposed to be random, but this is not random. You have limited resources to conduct audits. I attended the webinar a couple of weeks ago about the post-registration audit, and you're only able to do a small percentage of all filings now. Filling up that already small number with registrations that have already been scrutinized as a result of this proceeding, I think is unlikely to greatly improve the accuracy of those registrations, but it could interfere with efforts to improve the accuracy of other registrations. And stakeholders have already expressed concern that proceedings may be instituted by bad actors for reasons other than ensuring the accuracy of the register. So causing registrants further expense to undergo an audit only exacerbates the potential for mischief by bad actors. Turning to the, and also I think according to the NPRM, you're estimating as many as 3,600 of these proceedings a year. And I know not all of those are going to be due for post-registration filing during that period, but even if you consider it spread across 3 or 4 years, that's a pretty substantial chunk of what you have available to do each year. Okay, I have a lot of questions about the role-based access proposal. So let's say that the ownership has been assigned to a new attorney or to a new owner. The new owner wishes to cause its attorney to become the new attorney in these registrations. How will they do that? And is the answer different if they have recorded the change of ownership with the assignments branch versus if they have not yet recorded the change of ownership? I know it says that the attorney who's currently in the record is supposed to withdraw once they know, I forget what the rules are, I have them here. Anyway, once they know they've been discharged, I think is one of the times when you may withdraw. But you have up to 30 days to do that following when, well, that's another point, is I think that it should say following 30 days after the attorney learns that they have been discharged, rather than just 30 days after they've been discharged, if you consider that discharging the attorney includes transferring ownership of the registration. It seems to me that the person remaining in the record obviously cannot be the attorney for an unrelated new owner with whom it has no attorney-client relationship. But that doesn't necessarily mean that that person is going to be immediately informed by the parties involved in this transaction that, hey, you've been discharged by virtue of this assignment and you need to withdraw within 30 days. So I think there should be some, notification 30 days after you find out. But let's say that you are the new owner and you want to record the assignment, but you have some problems. You found in your diligence when you went to acquire this portfolio that there are some errors in some of the registrations that inadvertently had identified the wrong state of incorporation, for example. So in order to be able to record the assignment, which lists the correct state of incorporation, you need to file a Section 7 to get those registrations fixed. Now, who is going to have the role-based access to make that correction, which is a condition precedent to recording the assignment? Anything more that you can say about how this role-based access is going to work, especially in the case about transfers of ownership, would be really, really helpful. In terms of preparing the withdrawal form, I've had some bad experiences with that in the past, but I've reported them and I'm hopeful that the comments have resulted in some changes. But for example, let's say you're discharged by the applicant, but the applicant is an ex-US domiciled entity required to have US counsel. How will the attorney withdraw, thus rendering the ex-US domiciled registrant without US counsel if they do not have any information about whether a new US counsel will be appointed and who that might be? Also, will we be required to fill in stuff like the registrant's email address and domicile address just in order to have access to the forms to allow us to withdraw? I see my time's up. Thank you.
Thank you very much, Allison. I'm going to suggest that you file formal comments so that we get all of that information and can review it carefully. I think you raised some good points that we need to consider as we move forward. So I'm happy to encourage you to go, as I know you will, regulations.gov and file those comments so we can look at them more carefully and think about how they would work in the final rule. So thank you very much, Allison. I appreciate the input. I don't have any comments for you right now, unless Bob, do you have anything you want to add?
I don't. There was a lot there. I will say, we are of course aware of some of the issues with submitting forms, and we are actively working on those. And on the ownership issue, it is a complicated issue in terms of attorney recognition. So I would echo Amy's comments there that please submit formal comments with your concerns.
I sure will. Thanks so much.
Thank you. Our next speaker is Ted Davis.
Thank you. I have 3 questions, each of which relates to the initiation of an ex parte proceeding. The notice indicates that a prima facie case requires only a reasonable predicate concerning non-use, and there does seem to be a consensus that a prima facie case is something less than proving the case by a preponderance of the evidence in the testimony. But the notice also recites that the office bears the ultimate burden of proving non-use by a preponderance of the evidence. Does this standard apply as well to petitions initiated by private parties? My second question relates to what happens if a petition establishes a prima facie case of non-use, but it's not accepted for some other reason. For example, a failure to describe the petitioner's investigation in sufficient detail. You have indicated that the director will not add to a deficient petition, but can the director otherwise avail himself or herself of the evidence submitted in support of the failed petition in support of a director-initiated proceeding? And then finally, the notice indicates that if a proceeding is instituted, the petitioner will not have any further involvement. But can a petitioner withdraw or supplement its petition prior to the director acting on it? If, for example, the petitioner is paid off by a registrant, or alternatively, the registrant provides the petitioner with evidence of use as of the relevant date.
Thank you, Ted. I'm reading your comments in the caption as well, trying to process them. I think I don't know that we can answer any of those questions today. I think that if you submit them in your formal comments, that will give us some time to internally digest and figure out what we think the answer is. Particularly on the second issue, that's something that we need to consider how we're going to address. If you have a preference for how you would like us to address any of those, we would greatly appreciate that, not just pointing out the issue, but how you think that it should be handled. The NPRM does not, of course, go into these issues, so it's really a matter of implementation, drilling lower, down further than the rule. And so we're happy to take in any of that information through the formal comment period, but I don't have any comments on that today. Is there anybody on my panel who would like to answer any of those or have anything to say? I guess that's a no. But thank you so much. I knew your questions would be very thoughtful and stump the panel for a few as we have to go back and consult and figure out how we might try to answer those questions. We will certainly do that. The next speaker is actually Matt Frisbie, who emailed me the questions that he was going to ask, and I will go ahead and read out his questions. And because he gave them to me with plenty of time, we were able to have some answers ready. Mr. Frisbee's question, first question, it is clear that the director cannot supplement an inadequate third-party petition unless the director initiates his or her own proceeding. However, will the director be able to conduct additional diligence to verify the authenticity of evidence submitted by a third party or the registrant, or is the director's review limited to the four corners of the submissions and the registration file wrapper? Thank you for the question, Matt. Under proposed Rule 2.92, an expungement or reexamination proceeding will be instituted only in connection with the goods and services for which a prima facie case of relevant non-use has been established. The PTO's determination of whether a petition has established a prima facie case is based on the evidence submitted with the petition, as well as any other evidence already available in the USPTO's registration record, which includes the application file. USPTO will review the evidence submitted with the petition to determine its relevance and probative value. In certain cases, that review may result in a determination that evidence is not persuasive or should not be given any weight in the determination. We anticipate that generally this review will be limited to the registration record and the evidence submitted by the petitioner, but if other evidence that affects the probative value of the evidence is considered, we will provide that evidence and explain it in the USPTO's petition determination. Okay. He gave us warning, so we were able to have our answers at the ready. And his second question, In the NPRM, most office actions will have a 3-month response deadline under Rule 2.62 and 2.163, but the proposed deadline to respond in an expungement or reexamination proceeding is 2 months. Can you elaborate on the rationale for the difference? Yes, we can. The proposed 2-month response period for expungement and reexamination was proposed because these proceedings are supposed to be faster and more efficient than other available options for cancellation due to non-use. In addition, unlike other office actions issued during the application process and in connection with post-registration maintenance filings, which may raise a variety of issues, office actions in these proceedings are focused solely on the issue of use of the registered mark in commerce. The USPTO believes that the proposed 2 months response deadline for these proceedings is sufficient because most registrants are likely to already have evidence of use that is contemporaneous with the relevant date at issue, and if in fact such use was made. So while I understand from a practice perspective, it's nice to have every proceeding before the office be matched, and so there's no surprises because there are different drivers, different policy rationales for what we're trying to do and the speed in which we're trying to do it. We are having to create different timelines, so we understand that can be an issue, but they are certainly designed for a reason. But if you have thoughts about how they should be different, we'd like to hear it in your formal comments. So that's all from Mr. Frisbie. And do we have Ms. Russell or Mr. Moore available yet? Mr. Moore?
Thank you. Can you hear me now?
Yes.
Okay. Thank you for having the roundtable. Sorry it took me a while to get my browser configured to do whatever it's supposed to do. First comment is, in cases involving international registrations, I'm assuming you're going to notify WIPO, and will you require a statement by WIPO to the USPTO that WIPO has in fact sent a notice to the holder of record? Second comment is, in some of your slides you showed an examiner being involved in the petition for expungement and petition for re-exam. And my question is, would that mean it's an examiner like a post-registration examiner who's not necessarily an attorney, or would it mean that it's an examining attorney, someone with a law degree? And third comment is on withdrawal by an attorney or registered practitioner. Is there any consideration given to a simple statement that you've lost contact, especially after a first renewal is filed and there's a period of 10 years between when the attorney may speak to the owner of the registration until something else happens? In my experience, it doesn't happen very often, but it does happen regularly that you just have no way, as the attorney, what's listed as the attorney of record, you have no way to get a hold of the owner. The address you use, the email or the postal mail comes back undeliverable. Email doesn't get any returns. And from a practitioner standpoint, of being able to just say we've lost contact with the owner, I think would serve the public interest. So it does not appear that the owner is getting the information from the fact that an attorney of record is listed. Thank you.
Thank you, Mr. Moore. With regard to your first question about Section 66 registrants, at the institution of a proceeding, the notice of the institution of proceeding would go directly to the international registrant, not to WIPO. If the proceeding was successful and there was a ceasing of effect as to all of the goods and services or whatever was attacked, and there was then cancellation, then at that point we would issue a notice of ceasing of effect to the International Bureau of the World Intellectual Property Organization. But the communications regarding the institution of proceeding would not go through WIPO. They would go directly to the registrant. I hope that makes sense. On your second question as to who is the examiner, that's something that we're still working on. Certainly, these are complex proceedings on use and the evidence involved. So, at this point, we are considering that it would have to be experienced folks, attorneys who are reviewing these, but we're still, we're not sure how many of these we're going to get and exactly how we're going to staff it, but we know that the issues are going to be complex, and we're prepared to deal with that and have some very experienced folks working on this as we roll out these procedures. So I do think that we will be having attorneys. Will they be the original examining attorney that looked at the file? No, these would be a separate unit more than likely, but we're still working these things out. And as for the comments on withdrawal, that's a very helpful fact pattern for us to consider as we move forward. So I think we'll have to take that back and consider that as we look at the final rule. I'd love it for you to submit formal comments so that we can have it as part of the rulemaking record. That would be very helpful to us. Bob, did you have any comments on any of those issues, or correct me if I got anything wrong there?
Yeah, I mean, just on the withdrawal question, of course, we're going to have to update our forms accordingly, because right now, if the rule says attorney recognition ends at certain periods, including registration, then your withdrawal can simply say recognition is ended. Of course, as the speaker pointed out, that's no longer going to be the case. So we will need to update our forms accordingly. And I will just also point the speaker to the rules of professional conduct, which basically indicate that the practitioner may withdraw if the client fails to fulfill its obligations or if the representation has been rendered unreasonably difficult by the client. So that might be an area. But again, we will make sure to look at our forms when we make this change to make sure that all the withdrawal options are there in the form for you.
Thank you very much, Mr. Moore. I appreciate it. Do we have Ms. Russell connected yet?
Thank you. Ms. Russell is having computer difficulties,
okay.
So she's asked that we just go ahead and skip her. And that's
okay.
all of the pre-registered speakers. So now we can move to the questions that were submitted via email today. And so I will now turn it over to Mr. Robert Lavash.
Bob, did we want to look at some of the ones that were submitted ahead of time?
Sorry, that's exactly what I was saying, but I was muted. I apologize for that.
Oh, well, great minds.
Which ones did we want to cover first here?
The sua sponte institution or petition.
Oh, okay. Sure. So that question, will the director enter anything analogous to a third-party petition into the public TSDR record for registration when it begins review of a record for an ex parte, expungement, or re-examination sua sponte? So we're talking about the director initiated here. Or will the office action setting forth the 2-month response period be the first notice that the registrant receives? Amy, I guess you want me to take that one.
Yeah.
So we haven't made a final determination regarding the relevant procedures here, but right now we anticipate that initial office action in the director-initiated expungement or reexamination proceeding will be the first notice that the registrant receives regarding the proceeding. But we do, if anyone has any formal comments on that issue, we encourage you to submit your thoughts on those. Let's see. Next question, will a registrant that files a 1A application with a good faith mistake as to use and then subsequently amends to allege a correct later use date without ever changing its application basis to 1B, nevertheless be vulnerable to cancellation by reexamination? The answer to this is that actually should not happen. So in an application under Trademark Section 1A, the applicant may not amend the dates of use to specify a date of use that is later than the filing date of the application. Therefore, in that situation, the applicant would not be permitted during examination to amend to a later use date without first amending the basis to 1B and then subsequently filing an allegation of use. In that case, the normal timing of when the use has to be shown applies. So I hope that answers the question. Next question, will there be any issue or claim preclusive effect of an ex parte expungement determination in favor of a registrant on a subsequent inter partes claim of expungement as to the same registration? And then the question says we would not expect so. Our answer is that the proposed rules do not provide that an ex parte expungement determination will have a preclusive effect in a subsequent inter partes expungement proceeding for the TTAB. Let's see, a related preclusion question. Will there be any issue or claim preclusive effect of an ex parte determination against a registrant in the event that it attempts to refile an identical application? For instance, if a 44E registration is expunged, would the registrant be able to seek another 44E registration based on the same underlying foreign registration for the same goods or services? The proposed rules do not provide that an ex parte expungement or reexamination determination would preclude the filing of a new application with a Section 44E basis. Next, is the remedy for claims of inter partes expungement intended to be cancellation of the specific category of goods or services analogous to its similarly named ex parte claim, or will it be cancellation of the entire class analogous to the existing inter partes non-use claim? The answer is that the new non-use ground for inter partes cancellation under Trademark Act Section 14 substantively follows the basis for ex parte expungement, namely that the registered mark has never been used in commerce in connection with some or all of the goods or services recited in the registration. So an ex parte expungement proceeding may result in cancellation of a registration in part or in whole of some or all of the goods or services, depending on whether the proceeding was instituted as to some or all the goods or services and whether the evidence establishes non-use as to those goods and services. Likewise, and consistent with relevant TTAB precedent, an inter partes petition to cancel based on this new ground could result in cancellation of particular goods or services or certain classes of goods or services or the entire registration, depending on which goods or services are covered by the pleading and whether the evidence of record establishes non-use as to those goods or services.
Okay, so that was a group of questions that were sent to us ahead of time. And then we have a few more that came in ahead of time, and we have a whole bunch on the email. So let me run through these quickly. In expungement proceedings, would evidence of extensive use or regulatory filings outside the U.S. be considered to support a claim of excusable non-use in the U.S., even if use in the U.S. has not yet commenced or regulatory filings in the U.S. have not yet been submitted? And of course, the answer to that is it's a case-by-case determination depending on the facts. Probably not, but I think it's a case-by-case, so we really can't give too much of an answer there. Number two, with respect to the ex parte proceedings, did the PTO consider including provisions addressing any of the following? And if so, why did the USPTO decide against such provisions? The first one being confidentiality concerns associated with the registrant's need to provide more detailed evidence of use or excusable non-use. And our response is, yeah, we are aware of those concerns, and we welcome your comments on how to deal with that. The more procedures that we have to create and impose, certainly the longer these proceedings take, and that was not the intent. So at this point, everything is of the public record, and that was done deliberately. But if you would like to see something different, please submit formal comments and let us know. Point two, allowing a registrant an opportunity to submit a limited response to a third-party petition with clear-cut evidence of use or highlighting flaws in the petition in order to assist the director in making the prima facie determination. Yes, of course, we certainly have considered that. I'd like to hear your views on it. From an efficiency perspective, it raises concerns in terms of trying to move these proceedings through quickly, but certainly we want to balance interests. Again, it's not an inter partes proceeding, so it can be difficult to add a lot of submissions between the registrant and the petitioner and the like. Third, allowing a registrant to set aside a default and reopen a proceeding if the registrant can demonstrate that it never received the notices regarding the filing of the petition or the institution of the proceedings. In that case, if there's no response and the the goods and services are canceled because of that, a petition to the director is available. As I said, that would be the remedy in this situation. Lastly, allowing a registrant to request an extension of the 2-month response period with a showing of good cause. If folks would like to see that, we welcome comments on that through the rulemaking process. Again, that will extend the proceedings, make them take longer, and determining what is good cause, in those situations, again, requires, more scrutiny by the examiner and more time. Okay, then with regard to third question, with respect to the ex parte proceedings initiated by third-party petition, will the director consider any evidence outside of the petition in making the prima facie determination? So we're still considering that. We already had that question. Still considering of how to address that, and certainly happy to have your comments on how far and wide you think the director should look in trying to evaluate the prima facie case. Lastly, let's see. This is the patent model response period comment. Okay, under the alternative proposal for office action, responses involve escalating fees. What happens if the applicant files an extension request and payment during the initial 2-month response period, but ends up needing more time than expected? So again, this is the patent model. And as I understand how the patent model works, you're not requesting extension so much as you are filing when you're ready. So that you could file at the 6 months, but you would have to have paid all of the fees in order to get that 6 months, and they, of course, go up every month. So I think that's how the patent model worked. It's something that seems a little bit complicated to implement, but we would really like your comments on it to see if that's something that you all are interested in. Again, our main model was the 3-month response period for all office actions because we thought that was cleaner and easier than the other options, and so we put that up front, but we would love to hear what you all think about all the different options and any more that you have. Okay, so that's all the questions that we got ahead of time. And now we can turn to the questions that have come into the box as we have been speaking today. So Bob, what's the first one?
Okay, first we have, regarding registrant's ability to show use after being challenged with an expungement re-exam proceeding, is token use sufficient, or is there a minimum level that must be established to overcome the action? Also, what if the registrant had some use, i.e. 6 months, but then ceased use after that? So I have some ideas about that.
You go right ahead.
Okay. Token use kind of suggests actual use. So if it's the case that it's not actual use, then it's not going to be sufficient. And as Amy mentioned before, these are case-by-case determinations. So we're going to have to see that we're going to have to determine that non-use was established or use was established by preponderance of the evidence, as the case may be. Also, what if the registrant had 6 months, had use 6 months ago, but then ceased or at some point? We have to remember that both re-exam and expungement refer to specific use at a specific time. Expungement, of course, is you're stating that it's never been used. So if you can establish that they use it at some point, that should be enough. And then when we get into re-exam proceedings, the registrant's going to have to establish that they used it as of the relevant date. So if that particular use that they did use doesn't establish that, then they're out of luck. Is there anything you wanted to add to that, Amy?
Nope, that was it.
Okay. Next, we had a question about the flexible response periods. I think there were more than just this question asked about the flexible response periods, but basically the question, why is this being considered? The 6-month period seems to be working well. And again, the related questions had to do with the amount of time that we ultimately ended up on in our proposal.
With regard to the answer to this question, the 6-month response period was built into the statute many, many years ago when we were using paper mail. And life has moved on since then, and we're in a much faster working environment. The data shows that, probably if you look at how quickly applicants respond to office actions. Quite a few, probably half, respond in the first month, and then a quarter respond in between the first month and the fifth month, and then the 6 months you've got about another quarter. So most are responding in that first month or two. And if that's the case, then why are we holding on to the, why are we not, it seems like it's not a big impact to have folks, they have the expectation that we need to move applications through the system more quickly rather than letting them languish. And what we've heard from a clearance perspective is that a lot of applications are sitting there, they're parked there and blocking new entrants onto the register. And if we could get those through faster, then certainly that would open up business opportunities for others to get on the register. So it really was a function that Congress thought that moving applications through the system more quickly would allow new entrants into the market and open up opportunities. So certainly we're looking at more flexible response periods in order to accomplish those goals. But Congress told us that we can shorten to 2 months, but we had to allow the extension all the way up to the full 6 months. So 6 months has not gone away. It's still there. It's just a matter of incentivizing responses earlier so that we can move applications more efficiently through the system. Okay, moving on.
Great. I realize I had skipped over one, but it's also related to another one we received later, and it has to do with the timing of the expungement petitions. So this question asks if expungement can occur between the 3rd and 10th year after registration, is the assumption that the Section 8 was allowed for excusable non-use. Otherwise, not clear how they managed to keep the registration for more than 5 years without showing use. And the related question was whether the registrant has to wait until the first maintenance filing to file its declaration of excusable non-use. I don't know if you want to take that, Amy, or...
Well, I'll take the first one. The expungement petition, if a maintenance document was filed and they submitted proof of use but it wasn't accurate, then a third-party petitioner had the evidence to show that the mark was never in use, that would be a situation where expungement would be appropriate. So it's where they've alleged use to the USPTO in a maintenance filing or in the prosecution of the application, they've alleged use, but it wasn't true. And we weren't able to catch it at the time because we didn't have the evidence that a third party had. So in that situation, it's not that they were not submitting something and maintaining their registration, it's they submitted something that was not true. And what was the follow-on to that, Bob?
The follow-on to that is basically if they have excusable non-use, they might want to hold on to their goods and services, and otherwise they'd have to wait until between the 5th and 6th year to file that declaration of excusable non-use. Can they defensively and proactively file that declaration prior to the normal maintenance period? And I think that's something that we should maybe gather some comments on.
Okay. Sounds good.
But currently there is, of course, not a mechanism for accepting a premature non-use declaration.
Okay, next question.
All right, this one I think has to do with the letter of protest procedures. If the USPTO examiner initially issued an office action and rejected the application due to a likelihood of confusion with a U.S. registration or prior pending application, and such rejection was traversed by the applicant, will the letter of protest filed by the interested party be reviewed by the same examiner or a different examiner, or will a different examiner be assigned to review the previous decision and new evidence submitted with the letter of protest? The answer to that is typically it's sent back to the assigned examining attorney. It's not typically sent to a new examining attorney. And the other question, okay, that was the same question that we already answered. Let me move on. There was more additional questions and concerns about the flexible response period. Why is the extension fee so high? This may prejudice low-income filers. It may force them to pay for counsel. Will there be a sliding scale for small and micro entities?
Bob, you might have to answer that one. I'm not finding it.
Well, yeah, I mean, currently we have not proposed a sliding scale, but of course this is the, the NPRM, and we invite comments on how you think that might work in this context. In terms of the extension fee, depending on which one you're looking at, the primary proposal I think was $125, and that matches our extension fee for filing a statement of use extension. All right, the next question. Could you spend a few moments addressing how the rules may create a perverse incentive to challenged registrants to just file a new application for the same mark and the same goods or services for which the mark is not in use?
Well, that, let's see. Well, that may be true. Isn't that always the case, that if you get an office action and you can't respond to it, that you can just abandon and then refile, and we're not necessarily tracking that and stopping you from refiling the same application. So I hear what you're saying, but I think that's kind of the way that the system is built. If you would like to see a system where we block the person from refiling the same person, the same mark, and how would you implement that? The same person, the same mark for the same goods and services. We certainly would love to hear if that's what you want us to do, and then how you would see implementing that. Happy to take comments on that. Anything to add on that, Bob?
No, I don't.
Okay.
All right. Next, I note your articulated reason for newly imposing a continuing representation post-registration. It empowers the PTO to treat last known counsel as counsel of record, to, for example, give notice of actions under the new cancellation proceedings. This potentially could impose an onerous obligation on counsel, possibly impacting, for example, subsequent claim of conflicts years after that, where there's been no service requested or performed for the registrant by that counsel. This may particularly impact situation where the lawyer has only been retained to register one or two marks and has no ongoing relationship with the registrant. Smaller practices may thus be particularly impacted. I understand this is a new requirement. This new requirement allows counsel to withdraw or revoke proactively. Do you contemplate that the rules allowing counsel to withdraw upon issuance of the registration be more pro forma, different from current, more onerous rules for withdrawal or revocation? So again, I think this gets to the question of, will our forms be updated accordingly when we make this change to make sure that we're contemplating all the potential reasons for the withdrawal? And the answer there is yes. And again, this is all within the context of the professional rules of conduct and your obligations there.
We have one more.
Yes. If the reason for changing response period to 3 months is to move the applications along, why would there be a proposal to split examination, informal examination, and then formal examination? This is the EU model that appears inefficient.
We're looking at a bunch of different options of how to improve the efficiency of examination. Now, certainly, I think you might all be aware of the increased application numbers that we're getting. We're seeing quite a surge in applications that are coming in, and we're trying to determine how to improve the efficiency of examination, improve the efficiency of the office, and different models that will allow us to do that. And everything's on the table. And so, as we looked at these response period options, as I said, our first option was, okay, let's just go with a 3-month response period, extendable one time up to 6 months, and keep it easy and simple, but as we were also at the same time doing TMA rule package work, we were also dealing with the surge, and we thought, well, why don't we put other options in front of stakeholders and see what they have to say if they think that would be an interesting way to move forward? What if we were able to, you know, deal with formalities and by a set of formalities examiners or that sort of thing, you know, the easier issues up front, handle those, get everything in line, and then in a substantive examination, have the examining attorneys focus on the substantive refusals and not the formalities refusals. We know countries around the world actually, like you said, in the EU and other countries, they split formalities and substantive examination into two different examining corps and two different procedures. Is that something that U.S. stakeholders think would be useful here? I think your answer is no, inefficient in the EU. But we would love for any input on that as to how to move applications more quickly. And for those who, for instance, you know, are filing applications where they're not including all the information in the application, why should that be sent to an examining attorney to deal with all of that? Why don't we have that handled separately? But the only way to handle it separately and make the requirements is to have a flexible response period. Otherwise, every time we ask you to change something in your address, we have to give you a 6-month response period. And so it kind of didn't make sense it doesn't make sense if you're trying to knock out the formalities examination first to give you a whole 6 months and then come back with you know, substantive examination, unless we could shorten it. Unless we could shorten it and get it all through faster. That was one of the drivers in us thinking about this. But we have two different heads going on. We've got the TMA implementation, we've got the, you know, the surge coming in, and we're trying to figure out if we can have one model that solves two problems for us. And so we're looking for your input to see what you think would be, you know, the way to get things through the system and make sure that new entrants can get on the register faster. So I hope that answers the question.
All right. See, one came in while we were answering that one, and it was, will the Estoppel effect have a time limit, or will it be a permanent bar? Is an interesting question. It is permanent in the sense, in the context of these proceedings, that once we've kind of reached that final determination of whether there was use or non-use, you can't bring another action on that same basis. But I'll also note that these are kind of limited by the statute anyway. So after a certain period, you can't file these. So I hope that answers the question.
You can always go to the Trademark Trial and Appeal Board, though. That does not bar the ex parte proceedings do not bar inter partes proceedings on the same registration for the same goods. Okay, is that all that we have here? Bob, do you have anything more coming in?
I don't have anything more.
Okay.
If there's anyone with their hand raised or anything like that and they want to submit a question, but I think it seems like we're wrapping up.
Wait, is Allison's hand up?
Yes, it is. May I?
It is. Okay, Allison. Yes.
The other question. Yes, that issue with Estoppel, I thought that's relevant to the interplay with the post-registration audit as well, because if you're not supposed to be able to challenge the goods that were already challenged as part of the non-use proceeding, you know, a lot of times there's a lot of synonymous or overlapping goods and services in a registration, and I think it could get into some difficult issues of parsing, whether, you know, looking at something that's in a different phrase separated by semicolons is in fact already been addressed in the earlier thing. Secondly, if the flexible response period is supposed to make things go faster, it seems to me that the patent model produces uncertainty about what the status of prior pending applications is. Because as I understand it, they would be marked abandoned after 2 months, but they would have up until 6 months to file an answer. And so it seems like unless you're going to wait the whole 6 months, you know, things blocked by prior pending are not going to go faster because you're still going to be waiting until 6 months, or you're going to let them go and then you're going to have to pull them back when the response finally gets filed at perhaps the 6 months. One thing that I forgot to mention previously, but is very important to me, is if you do carry out this proposal to wipe all of the attorney information from the database at the time that the rule changes. Please do not remove the attorney docket numbers. It's one thing for us to go back in and put our name and address and bar information in, but that's all static information. We can put it in 300 at a time. But having to put back in individual unique matter numbers is a whole different order of magnitude of work. And I don't think there was anything in the NPRM about the proposed burden, hourly or cost-wise, on trademark owners and their attorneys of having to restore that attorney information to the database. Thank you.
Very helpful, Allison. Thank you for that information. We'll take that under advisement. Anything there you want to respond to, Bob?
Yeah, I'm not sure I understood the last comment. I think when we do transition, if this rule does go into effect for the attorney recognition rule, I think our proposal was to leave in the correspondence information for the attorney, but delete them as the attorney of record during that transition period where we want people to come in and reappear.
It specifically says also delete the docket numbers. Yeah. Yeah, you're proposing to delete the docket numbers too. Yes, keep our correspondence info, but wipe everything else.
Okay. Okay, we look forward to your comments, Allison.
As always. Okay. Anything else come in?
No, that's all the questions we've received for today.
Okay. I'm going to turn it back over to you, Tasha, as the Mistress of Ceremonies.
Thank you, Amy, and thank you to everyone on the call for your questions and comments today. Now I will turn it over to Deputy Chief Judge Mark Thurman to provide closing remarks.
Thank you, Tasha. Can everyone hear me? Yes, okay. I wanted to make a couple of quick points here. One is I want to reinforce the message you heard throughout this program, mainly from Amy, but also from Bob. We really need your input and we really need your formal comments. So please provide those to us. The more input we receive, the better the ultimate rules will be. You guys are out there, handling the impact of our rules and procedures. So and you can foresee certain things that might not occur to us. And so the more information you can provide, the less bumpy the road will be once these new proceedings and changes go into effect. And then the second point I want to make, which is really kind of in closing, is to return to the theme that Commissioner Gooder presented at the very start of this, and that is the importance, indeed almost the sanctity, of the register. It is the bedrock of our trademark system in the United States, and it's critical that it is as accurate and reliable as possible. It's been an ongoing concern for quite some time about registrations on the register that shouldn't be there. The board, in fact, a few years ago, implemented a pilot program, an expedited cancellation pilot, for this very reason, to look into whether or not we could attempt to remove some of this dead wood more efficiently. We had kind of mixed results of that pilot, but one of the things we noticed was a very high default rate in cancellation petitions involving claims of non-use or abandonment. 50% or higher, in some cases up to 60% default rates. That's a message that Chief Judge Rogers and I have been, making pretty consistently for about 2 years now. And it's an important point, and I think it reinforces the approach that Congress took in the TMA to expand even more the ways to clean up the register. So the involvement of the board in these proceedings is going to be primarily to appeal, to handle appeals, and we do have the new expungement proceeding, but it's all part of a whole. And so we look forward to implementing these new proceedings. We welcome all of your input, and we all are in this together to try to get the best register that we can. So thank you.
Thank you. We did receive one last question while Deputy Chief Judge Thurman was speaking, and that was a question about when do we expect to put out the final rule package. We do not have a set date to put out the final rule package. Comments are due on the notice of proposed rulemaking by July 19th. So at that point, the policy team led by Robert Lavash and Amy Cotton will review the comments and begin working on the final rulemaking. And the other date that I will point out is that the statute requires us to implement for letters of protest and the non-use cancellation provisions by 1 year after enactment, which is December 27th, 2021. Updates will be, of course, provided on our website, and so we encourage you all to subscribe to Trademark Alerts if you are not already. Also on our website is information about providing formal comments. Formal comments will be part of the official record and, as I just mentioned, reviewed and responded to in the final rulemaking. They are due by July 19th and can be submitted at www.regulations.gov. A link to the slides from today's presentation are posted at the bottom of the TMA page on our website. This roundtable was recorded and the video will be made available on the same page on our website within 2 to 3 weeks. We will email links to everyone that registered for today's program once the video is available. Thank you all once again and have a great rest of your day.